On April 29, 2022, the Vernon County Sheriff's Office in Wisconsin got many reports that a gold SUV was driving approximately 70 miles per hour in a downtown area in Westby, Wisconsin, and was passing vehicles in the left oncoming lane as well as vehicles parked to the right.
Turn the car off and step out right now. Turn the car off and step out.
Why?
The report stated that the SUV was passing vehicles in the oncoming lane to the left, as well as vehicles parked to the right. Around 10 minutes after receiving these reports, Chief Philip Welch of the Village of Valley Police Department noticed the vehicle traveling 106 miles per hour in a zone with a speed limit of 30 miles per hour and pulled over the driver, who was later identified as student Amanda McCaig, who was 35 years old. The interaction was caught on Chief Welch's body camera as it occurred. Paul Across, number 146. He was traveling 106 miles per hour when he arrived in town. I will give a response at the County B level. It doesn't matter, you pulled over on the 900 block, on the 900 block of Central. Stop the vehicle immediately and exit the building. Put the automobile in park and exit the vehicle. Why? Why do you need to get out of the car? 146, you need to get out of the car. Get out of the car at this very moment. Leave the vehicle immediately.
Come out of the car.
Who am I endangering? Who am I endangering?
What kind of key fob do you have? I really have no idea. I'm going to do my best to make it to the lecture with you. What will constitute your compliance is getting out of the car, the officer said. I won't be getting on this car. Can we just agree on that? You are being arrested for endangering others by your reckless behavior. That qualifies as a criminal offense. After Miss McCaig showed a persistent unwillingness to leave the vehicle, Chief Welch informed her that she was being detained for felony reckless endangerment in accordance with Section 941.30 of the statutes of the state of Wisconsin. When someone recklessly puts the safety of another person in jeopardy,
I'm going to stand here till you do.
Under circumstances that show utter disregard for human life, that person has committed the crime of reckless endangerment in the first degree. Additionally, the law specifies that whoever recklessly endangers another's safety commits the crime of second-degree reckless endangerment. In the case of State v. Williams, which was heard by the Wisconsin Court of Appeals in 2015, the court ruled that in order for the government to prove the crime of reckless endangerment, it must show that the defendant endangered the safety of another human being through criminally reckless conduct. Now, according to Section 939.24 of the statutes of Wisconsin, an individual commits an act of criminal recklessness when they create an unreasonable and substantial risk of death or great bodily harm to another human being and are aware that their conduct created that risk. This definition of criminal recklessness is included in the definition of criminal recklessness that can be found in the statutes of Wisconsin. According to the statutes of Wisconsin, the term great bodily harm refers to any injury to a person's body that either creates a substantial risk of death, causes serious permanent disfigurement,
Get on the ground.
causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or causes other serious bodily injuries. These are the types of injuries that fall under the definition of great bodily harm. The law that prohibits reckless endangerment can be broken in several different ways, including by driving at a high rate of speed and engaging in other sorts of risky driving behavior as assessed by the courts. For example, in the case of State v. Lechner, which was heard by the Supreme Court of Wisconsin in 1998, the court ruled that a driver engaged in reckless behavior when a witness observed the vehicle being driven by the defendant swerving in and out of traffic at a rate of speed that was significantly higher than the limit that was posted, and when, on at least 2 separate occasions, the defendant drove his vehicle across the double yellow center line of the highway, accelerated, and passed a different vehicle. The judge and the jury came to the conclusion that every time the defendant drove his vehicle across the center line of the highway, cut off another vehicle on the highway, and then abruptly re-entered the traffic lane, he created a separate unreasonable and substantial risk of harm to a different human being. This risk was created for the driver of the vehicle that he had just cut off on the highway. In light of this earlier decision, it is quite possible that a judge will conclude that Miss McCaig recklessly put the lives of other motorists in danger when, while driving at a high rate of speed, she weaved in and out of traffic and passed other occupied vehicles. Miss McCaig seems to make an attempt to drive away after repeatedly refusing Chief Welch's demands to exit the vehicle. In response, Chief Welch enters the vehicle in order to physically prevent Miss McCaig from driving away. According to Statute 946.41 in the state of Wisconsin, whoever knowingly resists or obstructs an officer while such officer is doing any act in an official capacity and with lawful authority is guilty of resisting or obstructing an officer. This provision states that a person is guilty of resisting or obstructing an officer if they do so intentionally. According to the jury instructions for this statute in the state of Wisconsin, resisting an officer is defined as opposing an officer by force or threat of force, and obstruction is defined as occurring when the conduct of the defendant prevents or makes the performance of the officer's duties more difficult. According to the observation made by the United States District Court for the Western District of Wisconsin in the case of Stabino v. City of Eau Claire in 2021, a number of courts have reached the conclusion that the failure to comply with a legitimate order issued by an officer constitutes probable cause for the arrest of an individual for the violation of this act. And in the year 2000, the Court of Appeals of Wisconsin decided that an individual's departure from a legitimate investigatory stop provided an officer with reasonable cause to arrest him for obstructing. This decision was made in the case of State v. Lynch. In this case, Miss McCaig vocally refused to vacate the vehicle multiple times and evidently attempted to drive away, which a court would very definitely decide was sufficient to at least create probable cause for Chief Welch to arrest her for obstruction. In addition, it appears that Miss McCaig attempted to drive away from the scene of the incident. In addition, the statute of Wisconsin provides in section 346.04 that no operator of a vehicle, after having received a visible or audible signal to stop his or her vehicle from an officer, shall knowingly resist the officer by failing to stop his or her vehicle as promptly as safety reasonably permits. This means that if an officer tells an operator to stop their vehicle, the operator cannot knowingly resist the police by continuing to drive. Although the plain language of the statute seems to apply only to a failure to stop when initially signaled to do so, the Supreme Court of Wisconsin cited it in the case of State v. Smith in 2018 to support the proposition that once seized by a police officer during a traffic stop, a driver may not leave until the traffic stop is finished. This was despite the fact that the plain language of the statute seems to apply only to a failure to stop when initially signaled to do so. As a result, a judge might reach the conclusion that Miss McCaig violated this legislation when she attempted to drive away after Chief Welch ordered her to step out of the vehicle. This is something that is possible given the circumstances. Miss McCaig was charged with refusing by failing to stop, resisting or obstructing an officer, speeding on a city highway, recklessly endangering safety in the second degree, unsafe right passing, and operating left of center, according to court documents. She pleaded no contest to speeding, failing to stop, and resisting or obstructing law officers on November 29, 2022. Her charges of operating left of center, reckless endangerment, and risky passing were dropped, but they were read in, so they may be considered in sentencing. She was fined and granted credit for her jail time. According to court records, Miss McCaig was evaluated for mental ability and found to be competent to pursue her case. Chief Welch gets an A for remaining professional and respectful, refusing to engage with Miss McCaig's repeated attempts to antagonize him and only employing force after she tried to flee. His Miss McCaig activities got him the grade. Chief Welch gave Miss McCaig many chances to depart the vehicle on her own, but only removed her by force when she tried to drive away, allegedly to prevent her from fleeing again. This despite the fact that a judge would likely rule that Chief Welch was authorized to remove Miss McCaig from the vehicle after she repeatedly refused. In addition, Chief Welch could have answered Miss McCaig's questions about why she was being detained more explicitly, but he was not legally required to do so, and he generally treated Miss McCaig and her companion with courtesy and respect. Even if he had answered Miss McCaig's inquiries about why she was arrested more precisely, this was true. I applaud Chief Welch's patience and professionalism and encourage other cops to emulate him. Miss McCaig got a failing score because she drove unsafely and recklessly, was furious and hostile throughout the conversation, rejected Chief Welch's directives, and tried to flee in her vehicle. Her passenger admitted that Miss McCaig had stopped taking her medicine. And if her mental health concerns interfered with her decision-making to the point that she could not drive safely, she should not have driven. Despite my sympathy for Miss McKeag's mental health difficulties, her passenger revealed she had stopped taking her medicine. In light of the above, I wish Miss McKeag the best and encourage her to seek help for any mental health issues. Please let us know in the comments section below if there is a particular encounter or legal problem that you would like us to talk about. I want to say thank you for watching.